Okay, I can see that they're being able to log in, which is good on my end. Means my webinar is working. Oh, but I always freeze. I try to remember to shut my mouth, so whenever I freeze right there, my mouth's not wide open. And then I come back. All right, let me see here. I just think we just about got everybody. Give it just another second. Okay, well, welcome everybody to Austin Criminal Defense Lawyers Friday Free CLE that's co-hosted with a CAPS webinar system. We are so lucky today to have David Frank. I particularly want to say thank you to David. He is always such an excellent presenter, but this one I kind of grabbed him at the last minute, and I really appreciate him filling in because I had somebody cancel on me, and it was just amazing how quickly David agreed to do this. So I really appreciate it. He's a past president of the Austin Criminal Defense Lawyers. I know that he currently serves on the strike force for TCDLA, was involved in the Val Antonio help that we all tried to do for the strike force in this area. David's board certified in criminal law and graduated from Vermont Law School. I always loved that part of it, and ended up in Texas. It seems like weather extremes to me.
That's right.
So welcome everybody for David speaking on eyewitness identification.
Well, thank you so much, Betty. Thank you for having me, and thank you everybody for being here today. Eyewitness ID is a topic I've talked on before. In fact, I've talked on it for many, many years, and I've seen the science, the research, the law, and police practices all try to keep up. It tends to move kind of slowly, but over the course of many, many years, you can see how the subject matter has gained acceptance in the scientific community, and then along with that later, the legal community. So some basics about eyewitness ID that everybody ought to probably know about and maybe already does. Oh, this is not, there we go. More than 75,000 people become crime suspects each year in the US based on being identified from lineups and photo spreads. And we're going to talk about different kinds of lineups and photo spread procedures, but it's important to know that eyewitness ID is a big factor in people getting arrested, becoming suspects, and having to go through the criminal justice system. Between 1989 and 2018, more than 2,000 people were wrongly convicted and then were later exonerated in state and federal courts. So we're talking about a large number of people who were exonerated, but keep in mind, these were the people who had the advantage of DNA or some other evidence that came along to show that in their eyewitness ID cases, the eyewitness witness got it wrong.
So David, are you moving through the PowerPoint? Because we're still on one.
You are? Okay. Let me try to share that again.
Sorry. We're still just seeing the first slide.
And better?
That's the slide that says nobody knows.
Right. Okay. But you can see that. I'm going to go back one.
Yeah. Now it's moving back. Okay.
All right. So, you know, on this issue of how many people get falsely convicted every year, we don't really know. We know about the DNA exonerations, but we don't know about the many, many other people who were never exonerated, but were falsely convicted because of misidentification. But as of 2014, eyewitness misidentification testimony was a factor in 73% of the 312 post-conviction DNA exonerations in the United States. So of these very large numbers of people who are getting convicted, we do know that there is 73% of them being exonerated because of DNA. So today, I wanted to talk about recent developments in the research and law in Texas that I think everybody should know about when they get a case that involves eyewitness ID. I'm not going to have time to talk about qualifying experts or what you can do to prepare your discovery, although I think some of that will become obvious as we go through this, or jury selection, or maybe even jury charges. That might be a subject for another day. But today, I want to talk about the eyewitness ID procedures that are used throughout the country and in Texas, the scientific research and best practices that are being discussed and developed in universities, and how we go about excluding bad identifications pre-trial. So the first thing I want to talk about are procedures that are used in eyewitness identification throughout the United States. A couple of basic terms. When we think about lineups, we often think about people standing shoulder to shoulder with a measure behind them so we can judge their height, what they look like. But it's important to know what they're called, what these people are called. So we have fillers, innocent people who are put into a lineup that we know are innocent, did not commit the crime. And then we have the person who is the suspect. And the suspect may or may not be the actual person who did the crime. That's what this ID is trying to identify or pick out. They're often called the suspect or the perpetrator. I'm sorry, they may be a suspect. They may be a perpetrator, sometimes called a culprit. And a question comes up for researchers who are doing work in the lab as opposed to field work, which is using actual violent crime. But in the lab, they want to know, how often do witnesses identify an innocent filler from a lineup? And if you had to guess, anybody have any idea? I mean, you can write it down. We can talk about it later. But the answer is 36% of the time.
Wow.
36% of the time, witnesses in the lab are picking out innocent fillers. And among those witnesses who made an ID, 36% identified a known innocent filler rather than a suspect. And that is across the board, whether they're doing simultaneous or sequential lineups. We'll talk more about that in a minute. There are two different major procedures that gets used, but you can see it's a little over a third of the time. And that's a lot of innocent fillers who are getting picked by eyewitnesses. So let's talk about some different types of procedures. There is what's called the live lineup. And that's kind of what you might think of, you know, from the movies and TV, where they stand people up side by side. And this does have certain advantages. You can see the person's height compared to other people. You can see their hair, their head, their face, their chest, the clothes that they were wearing, perhaps at the time that they were arrested, their arms, their hands. This is better in some ways than a picture of a headshot of a person who's being shown to a witness. However, you know, it has certain drawbacks. It takes time to put this together. It's expensive. You have to try to find people who kind of look like your suspect or maybe look like the perpetrator. More on that later. But that is difficult as opposed to doing a photo array. And you never know whether the suspect is going to manifest or show some type of trait of nervousness that might signal and something to the witness to have them picked out, where the fillers, the innocent fillers, might not have that same sense of nervousness or anxiety. So researchers are always looking at these, testing them, trying to figure out what procedure is best. Turns out that this procedure is kind of frowned upon now. It's not that it's any more or less reliable, but researchers are now pushing and encouraging sequential lineups. We're going to talk about that in a minute. This is an actual lineup, and you can see it's not a very good one. It's hard to see the faces. And two of the people appear to be African American. The rest seem to be either Hispanic or Caucasian. And if the person who picked out or described a perpetrator who was African American, really kind of narrows this lineup down to just two people, maybe a flip of a coin, which makes it more susceptible to misidentification. So the perpetrator was described as a Black male. As you can imagine, there's not much of a choice here. It's really a choice between two people, and these two Black people have very different complexions. It's not much of a choice at all if you have a anxious witness who's looking to cooperate and pick somebody. So that's the live lineup. There's also what's called a show up, and these are really the worst kind of ID. As you can imagine, person who's in a show up, a single photo ID or a single person show up, there's just a lot more of an inclination for a witness who wants to cooperate, who wants to help, or is being encouraged to help, to pick that person. They're usually standing in handcuffs. They might have police surrounding them. It might be at the crime scene. It might be at night. And there's a great temptation for witnesses to pick out individuals who are in a single person photo array or a show up. And so these are really discouraged. We're gonna see procedures that really kind of tell police don't do single person show ups. Same goes for single photo ID. If I show somebody one picture and ask that witness, is this the guy? The witness is going to want to cooperate. They're going to want to pick somebody. They're not going to want to just let somebody go and think that the investigation will end if they don't pick somebody. And so picking a single photo ID for somebody who's not sure might be a better option than just to say, I don't know, or giving them the option of choosing among many people instead of just one person. Those are the single photo IDs. Then we have sequential lineups, which are really kind of now the procedure of choice in Texas. And a single sequential lineup looks something like this. You show the person a single photo, followed by another, and another, and another. And then in this case, this was an actual case. You might want to show them larger photos, real people. This person happens to be, the description of the person was bald, some facial hair, roundish type of head. And so you'll see that some of these photos kind of look like the description. This guy actually has a tattoo on his neck, which is not an appropriate procedure if you have somebody who is described as having a tattoo and he's the only person in the array that has a tattoo. That's going to be a tell. The person is going to be more likely to pick out, the witness is going to be more likely to pick out that person simply because they have that difference. And you want to make sure that you call this out if you're the defense and you want to point out that the photo array was not fair. You also notice that the backgrounds are kind of similar. They're all kind of grayed out and grainy. The heads are sort of centered somewhat, not too high or not too different from anybody else. So there's some things that are good about this lineup, but the fact that the suspect had a neck tattoo and nobody else did makes him stand out, and that should not be presented to a jury. There is a institute we have here in Texas, LEMIT, which comes up with procedures. In fact, they have a model policy that all law enforcement agencies have to either adopt or come up with their own. And LEMIT had, they're through university here in Texas, they came up with a procedure where you should never just show single photo ID arrays. You should start with a filler in the lead position, which is just a blank piece of paper, then show them individually the photos that you want to show them. Don't show them the last two, which are also blank, but leave them in your pile so that the witness thinks there may be other people and they're not tempted to only pick the people that they were shown. So that's an interesting procedure. I don't believe APD has followed that yet, but they may in the future. So those are the single photo IDs and sequential lineups. And then there are the simultaneous lineups, or the 6-pack, photo spread, photo array. It's what you'll hear them called as. And here again, we have those same individuals, but this time they're on one single sheet of paper and the witness can look them over and compare them. This one's a little bit better because the guy in number 2 position, he has that neck tattoo, but it's not really obvious, although I would call this out if I were having a pretrial on it and say it was not a fair array. But as you can see, background is grainy, heads are about the same shape. They all have facial hair. They're looking straight at the camera, none are in profile. One of those guys, number 6, is a little bit darker than the rest. That's slightly suggestive. But the key here is we're looking for, as defense lawyers, what makes this person who was selected, what makes that person, what caused them to be picked out? Was there anything selective, or I'm sorry, suggestive about the procedure? Here's another 6-pack that came up in one of my cases. And if you look at that, you can see one of these guys stands out more than the rest. And it's this guy in the number 3 position who actually happens to be the suspect. There's no shaded background. He appears higher in the frame, and you can see his upper body, and you can't really see that for anyone else in this photo array. So this photo array is not very good. It is suggestive, and that should be brought to the attention of the trial court. So those are the procedures that get used. As I said, photo arrays are frowned on now. Sequential photos are preferred. APD has adopted that procedure. And the scientific research and best practices that has evolved over the years is also very interesting because, you know, if you're a lawyer and you're thinking that the procedures today don't really address the problem that's in my case, I think it's highly suggestive, but there are no cases that talk about it. Don't give up. The research may be there, it just may not have been adopted in the appellate cases yet, and you may get to make that new law. So think about what are the suggestive issues in the identification procedure. So the researchers are looking as a goal for a good identification procedure, and that doesn't just include a positive ID. It also means excluding innocent people so that they can just get up and leave. We don't want to prosecute or have misidentifications. So the lower rate of false negatives while maintaining the true positives is the goal for research and for law enforcement. We want to exclude innocent people from mistaken ID while positively identifying guilty perpetrators. And they break it down. Researchers try to be precise, and they look at the different phases of how memory works. When a witness sees a crime and observes it for the first time, they're encoding, they're acquiring information. And researchers like to talk about that process and study that process of how witnesses observe and are or do not observe what the actual events are. Another phase is storage, meaning how are they able to maintain or retain that information over a period of time, whether it's immediately after they observe a crime or months or even sometimes years after an event takes place. What happens to that memory in storage over time? And finally, retrieval, which is how well can they access that information. So for encoding, they look at lots of issues like the duration of or exposure of how long they witnessed a crime. If it was, you know, a car crash that happened in a fleeting moment, they may not be able to encode a whole lot of information. Weapon focus is an issue in research where, you know, if a gun or a knife is being used, a lot of times the victim of a crime is going to be focused on that weapon and not so much on the face or body characteristics of the perpetrator. Cross-racial ID, which is not really a racial issue, it has to do with familiarity. And researchers tell us that when people are more familiar with the faces of a certain type of group, racial group, they have better encoding than if they're trying to observe and remember the features of a person that's outside that racial group. Lighting, distance, and vision are obvious, right? Everybody knows that we need to have good light, have to be close enough to see it, and we have to have our glasses on or whatever it is that we need to be able to observe and encode. Intoxication can affect encoding. If it's an offense like a robbery and everybody's intoxicated, well, they may not be able to, they may not be good witnesses. They may not really observe and encode well. If their attention is diverted, maybe they have a close family member, friend, girlfriend, boyfriend who they're more concerned about in terms of safety during a violent incident, they may not be focusing at all on the perpetrator's face to be able to explain or describe it later to law enforcement. As I mentioned before, familiarity is a real big issue, and this is sometimes known as independent source. For instance, if someone you know very well commits a crime against you, and the police use a suggestive procedure to identify that person, it really doesn't matter that the procedure itself was suggestive. You know who that person is. And trying to attack the identification procedure is not going to be fruitful. So familiarity is definitely an issue in encoding. You may only know the person slightly, in which case encoding becomes more important. Then there's storage and retrieval. And time and the passage of time obviously affect how we remember things. Our memories get contaminated with the passage of time. New information, misinformation, and disinformation can all affect the way we remember things. If you think about your experience listening to the news, you think you know what happened the other day, and then suddenly they're telling you that it was actually something different, and that you start questioning your memory of the events because authoritative sources might be giving you different information, and that authoritative source may be a co-witness. Leading questions by the police, or anyone for that matter, could cause your memory to shift. Conversations with co-witnesses and witness factors like stress of the event, trauma, your attention is diverted, your perception is weak, you may have certain biases and expectations, and age. You know, as we age, our memories start to be they start to fade, and they aren't as reliable over a longer period of time. Sometimes, not always, certainly some sharp 90-year-olds out there. But in general, memory is sharper when a person is in their 20s and 30s as opposed to their 80s and 90s.
So we've had one question, David, about, do you know if there's any study about somebody who says they know the person and might misidentify them, like saying, I think it's this guy, and ask the law enforcement, is it him? And is there any way to attack that?
Well, using an expert is really going to be helpful for that. I think in any case where there are questions about memory, about encoding, about storage retrieval, and about identification in general that aren't obvious, and even in the obvious cases, or what we think are obvious, having an expert there is going to be very helpful. I don't really have time to talk about qualifying your experts or who these experts are, but I'm more than happy to talk to people about that later if you need a referral or just want to bat some ideas around. I'll also say the internet is a wonderful source for getting information about eyewitness ID. Almost all of these studies are published and are free on the internet. These scientists are not trying to make a lot of money off of it. They're trying to put that information out there so that people can use it, refer to it, cite it in their motions and their briefs, and try to get judges to agree. So back in 1996, Department of Justice became real interested in this issue of convictions based on misidentification. And they took a look at 28 jury trial convictions. Each of the individuals convicted got on average 7 years in prison. All of them involved eyewitness identification. And after the trial, all those individuals were exonerated. All right, small sample back in 96, but it was kind of speaking to a larger issue in our society where people were getting very concerned. You know, you'd see cartoons in the newspaper about lineups with a mouse, a rabbit, a refrigerator, and a microwave, and people just, you know, picking random objects. And I think that there was a sense that it wasn't being done in a very scientific way, that the procedures weren't really done in a methodical way, that it was whatever the police officer decided to do at the time. And if they wanted to really get somebody, they could encourage a witness to identify an innocent person just because the investigation was hot and they needed somebody. So the Department of Justice started making some recommendations. Double-blind studies. The person administering the test should not know who the suspect is when they administer the test. Even a good administrator, a good officer who's not trying to influence the outcome of the test could still do that inadvertently without knowing it, by verbal cues, body language, just the way the case is presented. So DOJ recommends doing it with blind administration. The administrator should not know who the suspect is. And one of the big researchers in the field, Gary Wells, he's out of Iowa, said the person who conducts the lineup of photo spread shouldn't be aware which member of the lineup or photo spread is the suspect. That was in 1998, and it's taken a long time for that recommendation to work its way into our photo procedures and our live eyewitness ID procedures, but it has worked its way in. It's not always followed. And when it's not followed, that is an issue that should be singled out. It should be brought to the attention of the court. Try to suppress the identification, especially in a case where there's no corroborating evidence. Eyewitness ID is it. You need to do everything possible to remove, to exclude and suppress those bad identifications. And if they weren't double blind or blinded, then you need to ask the judge to remove it. You also need to voir dire on it if it comes in front of the jury so that they know not to give it a lot of weight. Okay, so I mentioned Gary Wells. He writes a paper along with some others in 1998, and it's usually referred to as the white paper. And these white papers are kind of, they're sort of more important than just general research papers. They're peer reviewed, they're accepted by academia, they're accepted by law enforcement. Law enforcement consulted on this, and defense lawyers. And the recommendations he made, there were, I think, 4 of them here. Double-blind lineup testing should be used. That was the first one. He said eyewitnesses should be forewarned that the suspect might not be present. That's really important. Just like in a single photo lineup where the person is the only person that's being selected, and the witness might be tempted to say that's him. Even if you had a photo array or if you were doing them in sequence, it's helpful to tell the witness that the suspect may not be in that array. It makes it more fair. And if the witness is not sure, they can say none of the above, or I don't know. Giving that instruction gives them the leeway to do that. Another recommendation was a suspect should not stand out in a way that would draw extra attention to the suspect. That may seem obvious, but as we're going to talk about, when they put these photo arrays together, sometimes the recommendation is make the fillers look like the person that the witness described as having committed the crime, that they should look like the perpetrator. And others say, no, we don't want them to look like the perpetrator. We want them to look like the suspect who is in that photo array, right? Because if we don't, then the suspect is going to stand out. For instance, if, and this is an extreme example, but if your victim says, yeah, it was a tall white man with long hair, and the police say, no, we've got reason to believe it's this young female over here, and they put the female in the photo array, and they try to put in people that match the description of the perpetrator, she's going to be the only person. The suspect is going to be the only person in that photo array who will stand out, obviously. And that's probably not going to go to a lineup, but I think it illustrates the point that maybe it's better to have your fillers match your suspect rather than the description of the perpetrator. Confidence should be assessed and recorded at the time of the identification prior to any feedback. This, the researchers say, is one of the most important things. If there's low confidence at the time of the identification, it may not be a very reliable identification procedure. And worse, if that witness becomes more confident later after having given a low confidence identification, there's something wrong with that ID procedure. They shouldn't be getting more confident. Conversely, if they're very confident at the time of the procedure, researchers, at least in the laboratory, say that's probably a more reliable identification. Double-blind lineups are emphasized as one of the most important recommendations of these 4. We're going to fast forward later to another white paper by Gary Wells where he adds 4 more recommendations. But in 1999, DOJ comes out with Eyewitness Evidence, a guide for law enforcement. This is free. I've included it in the PowerPoint. There's a website there. It has excellent information for law enforcement and defense lawyers who want to cross-examine the officers on the stand. We think about DWI and how you would never go to trial without the NHTSA manual. Well, you really shouldn't go to trial without this, along with several other important sources of information, so that you can cross-examine. And this is where a lot of the ideas that come out later, remember, this is in 1999, this is where a lot of the ideas come out later that law enforcement adopt. In 2003, DOJ comes up with the Eyewitness Evidence, a trainer's manual for law enforcement. They actually develop a whole curriculum in 2003 for law enforcement, both at the federal and state level and local level. And they're now really kind of moving full force into training law enforcement to try to get it right. We don't want to arrest innocent people. We don't want to convict innocent people, but we still want to catch perpetrators. And so there's this balance, there's this tension going on where law enforcement, the defense, academia, the courts, everybody's trying to figure out how do we do this without just letting everybody go free? And how do we do it so that we can catch true positives. So the procedures are studied. The ABA, the American Bar Association, comes out in 2004. They endorse the recommendation for double-blind procedures, that the person administering the test shouldn't know who the suspect is. They endorse instructing the eyewitness, telling them not to assume the right person is in the line or spread. They increase the number of foils. This is new. Increase the number of fillers, foils, in the line and select them to match the particular eyewitness's description of the perpetrator. That's what I was talking about before. I don't necessarily think this is a good idea, but ABA is saying that this is something that law enforcement should do. And the witnesses reciting in their own words how confident they are in the selection process is important whenever practical. They also recommend videotaping. And this is going to become really critical later on. As you're going to see, videotaping is going to be important for the defense to be able to ensure that the procedures were done right, or if they were done wrong, to call them out. Number 6, they recommend special jury instructions. Now, jury instructions on eyewitness ID are not allowed in Texas today. That doesn't mean that one day they might not be. They might be allowed. And so I would recommend that everybody start putting together jury instructions when you have an eyewitness ID case. Get it in front of the judge pre-trial, show it to the prosecutor, get everybody on the record, and ask the judge to include this at the trial. You might even be able to get the judge to give the instruction before the jury hears any evidence, just because eyewitness ID is that impactful. Also, they recommend getting expert testimony on eyewitness ID problem cases. They don't say you should get it on every case, and the Court of Criminal Appeals said it's not ineffective assistance as long as you had a strategy for not bringing on your expert. So that's a gamble. If you don't want to get an expert, you might have to defend yourself in front of the CCA. The report did not embrace whether sequential lineups or photo spreads were better. In fact, the researchers are kind of mixed on this about which one's more reliable. But you'll see that APD has adopted the sequential one-at-a-time photos rather than 6-packs, photo arrays, or photo spreads. All right, this is where it gets really important. This is where I learned a lot since the last time I gave this presentation. We have a new exclusionary rule in Article 38, Chapter 38 of the Code of Criminal Procedure. And I think it's important to spend a little time on it. It starts out as HB 215. And I'm going to talk a little bit at length about that. I think it's important to be familiar with Article 3820. Keep in mind that Chapter 38 also houses 3823, our broad exclusionary rule, and 3822 about witness statements. So they put it in this chapter for a reason. They want to be able to exclude bad IDs. And APD incorporates parts of this in their general orders. And I'm going to talk about the general orders for APD. I'm also going to talk a little bit about LEMIT. I've mentioned LEMIT, the Bill Blackwood Law Enforcement Management Institute of Texas model policy. 3820 talks about creating a model policy for eyewitness ID that all law enforcement need to adopt, not just the big city agencies with 200,000 people or more, but the tiny little podunk towns that have police departments have to have an eyewitness ID policy according to 3820. And this is it's a broad area to cover, but case law is really important to know about in these cases if you're going to litigate them. So 3820, let's talk a little bit about this. It passes in 2011 and it gets amended in 2017. So there's not a lot of litigation about this. It's only been around for a couple of years, and obviously COVID interrupted a lot of our trial practice and our appellate practices. So there are no cases about 3820. And so it's important to look at it real carefully. 3820 requires Texas law enforcement agencies in the state to adopt written eyewitness ID policies based on best practices. That comes from research. That comes from the people in academia. So these best practices are being pioneered and developed in academia. They get adopted by law enforcement. Law enforcement goes back, they discuss it, they consult, they try to figure out what actually works. And it's still a developing field. They have to adopt best practices proven effective by scientific research on eyewitness testimony. And as I mentioned, the Bill Blackwood Law Enforcement Management Institute of Texas has developed a model policy. We're going to talk about that model policy in a minute. Here's the language 3820. Each law enforcement agency shall adopt detailed written policies regarding the administration of the photograph and live lineup ID procedures in accordance with this article. And the model policy or any other policy adopted by a law enforcement agency under subsection A2 has to include the following information regarding evidence-based practices. Here's the first part. It's in section 3C 2A. A procedure for selecting photograph and live lineup filler photographs or participants to ensure that the photographs or participants are consistent in appearance with the description of the alleged perpetrator. There it is again. I don't know why they insist on making people in these lineups look like the description of the alleged perpetrator instead of the suspect, but that's where the research in the law is today. That may change. In fact, studies say no, that's wrong, but that's what 3820 says. And two, that they do not make the suspect noticeably stand out. So there is this balance here, right? They want to make the lineup have people who look like the description of the perpetrator, but they also don't want the suspect to stand out. So police have to work on that, trying to find photographs of people who kind of match both. And my question is always, shouldn't the fillers look like the suspect so he does not stand out? In fact, there's a case from 1985 in Texas. Every photo array must generally contain photographs of individuals who roughly fit the description of the suspect. So if the officer gets up on the stand and says, hey, we're just following 3820, you may want to say yes, but the courts say otherwise. That's in a state of flux right now, but it's always a good area of cross when you have an officer on the stand as to why they're doing one or the other. All right, what does it also say? It says instructions given to a witness before conducting a photograph or live lineup ID procedure must include a statement that the person who committed the offense may or may not be present in the procedure. That's great. That's what the research says to do. That's what 3820 says to do. When the officer is talking to their witness prior to the ID procedure, tell them that the perpetrator may or may not be in that lineup. That gives the witness an out so that they can say, I'm not sure, I don't know. Could be, but I have a very low confidence on this. And the police have to write it down. 3820 does not include the following warnings that the model policy that Lemmet put together states. The police don't have to tell the witness right now that the investigation will continue whether or not you make an identification. All the research says that that's a really good instruction, a recommendation that you should give the witness, but 3820 doesn't include that. They also say you should tell the witness that you should not feel you have to make an identification. Gives them the out to say, I don't know, or that's not the person. It doesn't include that the statement that it is as important to exclude innocent persons as it is to identify the perpetrator. It doesn't say in order to prevent damaging the investigation, you should avoid discussing this ID procedure or its results. That's something that got recommended but didn't make its way into 3820. It does recommend blind administration. Everybody seems to agree that the administrator should not know who the suspect is, and that's true for both live lineups and photo spreads. So you should try as best as possible to get somebody who doesn't know who the suspect is when they're administering the identification procedure. And the Justice Department came out in January of 2017, and they delineated two different kinds of blind ID procedures. The first one is where the administrator is not involved in the investigation, doesn't know what the suspect looks like. That's probably the best. But then they said, when that's not available, you can do a blinded procedure where the administrator takes steps to ensure he or she cannot see the order or the arrangement of the photographs viewed by the witness. It's probably second best, right? They still might know who the suspect is. They still might be telegraphing who they think the suspect is, but at least if they're, randomized or they don't know what the order is, they might not telegraph it as much. That's what DOJ says in 2017 is acceptable. DOJ also says that to document the witness's self-reported confidence at the moment of the initial identification. And here again, they say confidence is often a more reliable predictor of eyewitness accuracy, that a witness's confidence than a witness's confidence at the time of trial. So you got to document their confidence. And finally, DOJ says you should document the ID either by video or audio recording or transcribe it. This is going to be really important because 3820 has a provision which I am going to suggest requires video recording. And if that video recording of the out-of-court ID wasn't done, I think it's subject to exclusion. We'll talk about that in a minute. 3820 continues. It says a witness should have a confidence statement. So we had DOJ saying, yes, you need to take a confidence statement now. Texas Article 3820 Code of Criminal Procedure says, yes, we should be taking confident statements from the witness, and that should be documented in any report involving eyewitness ID. So it's part of our code. And then 3820 goes on and it says, except as provided by subsection C. I've got this highlighted in green because this is where the exclusionary part of 3820 happens. It starts out by saying, evidence of compliance with the model policy or any other policy adopted under this article is not a condition precedent to the admissibility of an out-of-court eyewitness ID. If the cops don't follow procedures as we've set them out in 3820 or in the limit model policy, too bad, so sad. You cannot exclude that as a violation of 3820, except they talk about Part C. Part C, it says, I'm going to read this a little bit slower. If a witness who has previously made an out-of-court photographic or live lineup identification of the accused makes an in-court identification of the accused, the eyewitness identification is admissible into evidence against the accused only if the evidence is accompanied by the details of each prior photograph or live lineup ID made of the accused by the witness, including the manner in which the identification procedure was conducted. It's a lot of words, but essentially, eyewitness ID procedures only come in if the evidence is accompanied by the details, including the manner in which the procedure was conducted. What does that mean? It doesn't tell us, but it goes to, and if you look at the legislative history, originally they said that if any of the prior procedures was recorded, that was enough. Then in 3820, they adopted language that said that all of the procedures have to be documented. My position is the only way to adequately preserve the procedure is by video. It could be body cam or dash cam. It could be in the office, but it has to be videoed. In fact, accompanied by the details should only be by video and not rely on the officer's report, because the ABA best practices in 2004 said should be digitally recorded. The DOJ procedures in 2017 said the same thing. Gary Wells' paper in 2020 says you should video record the procedures, and APD's General Orders 40353H, which just came out this year. It's actually a reiteration. It had this provision in there before, but it said identification procedures will be videotaped whenever possible. There's a reason for that. There's a reason they put it in 3820. I believe that if they don't videotape that procedure, the out of court, on the street procedure to ID, then this should be subject to exclusion. They shouldn't be allowed to come in and say that they satisfy this provision just by having a few notes about the details and the manner. We need to be able to do our own investigation and call into question the identification procedures that may very well have been suggestive that led to the suspect being arrested. But if the judge says no, you've got lots of fertile ground to cross. So be aware of all of these procedures and sources. So I mentioned the general orders, APD's general orders. We use these all the time, right? When does an officer need to get authority to do something? Do they need to have video cameras in their cars? Do they have to wear body cams? It's all in there. And they have a whole section on eyewitness ID procedures. This latest version is from February of this year. They review it and update it continuously. You can find the latest version online. I have a web page here for the most recent version. So let's take a look at what the general orders say. They say for sequential lineups, those are the only ones authorized for investigative use. APD is not allowed to use any other procedure except in child abuse investigations, and then only with prior approval. So if you see a 6-pack with a bunch of adults and a grown adult witness who's making ID, you need to be standing up and objecting, saying this violates General Order 403 5.1. They have to have approval from a child abuse unit supervisor if they're going to use a 6-pack, a photo array, a simultaneous lineup. And that would go for live lineups as well, which APD doesn't do very often, but they do it occasionally. They've got a room for it. 40353H says identification procedures will be videotaped whenever possible. So again, we're seeing the emphasis and need for videotaping. They also recommend random suspect lineups are not permitted. So if a police officer just has a hunch, but doesn't have probable cause, but just wants to see whether somebody who is in the area might fit the description, might get picked out from a lineup, this rule says don't do that. We're not going to do random suspect lineups. It really discourages show-ups. It says don't use single photo IDs, don't bring an individual to the witness at the time of a crime. It is highly suggestive. They say field ID should only be conducted under the following exigent conditions. Here, exigent means, absolutely necessary at the time. 1, you got to get prior supervisor approval. 2, the suspect is detained within a reasonable time of the offense. They don't tell us what reasonable time means. 3, a lineup cannot be promptly arranged, and so you might have to do a show up. And 4, there's an immediate need to arrest the suspect. In other words, if you have time to put together a photo lineup and show them to the witness in sequence, you should do that. This should only be done when there's no time for a photo lineup, no time to do it properly in sequence, no time to give warnings. You have the suspect there. Used to be, researchers said, this was a good, show-ups were a good method for excluding the innocent. You could say, immediately whether this person is the perpetrator or not, because the witness could exclude them. APD's rules say don't do that. You should do a proper photo sequential lineup. Now, the general orders do not mention ensuring that the photographs or participants are consistent in appearance with the description of the alleged perpetrator. That's interesting because Article 3820 sure did. APD has chosen to take the position that the description of the alleged perpetrator is not essential for them to put together a lineup. In fact, the order says avoid using fillers that so closely resemble the suspect that a person familiar with the suspect might find it difficult to distinguish the suspect from the fillers. That to me suggests they want fillers who look like the suspect, not like the perpetrator, which is what 3820 calls for. There is that tension I've mentioned. This is an ongoing issue. Researchers are trying to figure out which instructions are best and what line of procedures are going to work and are most reliable. But that's the way the law is today. That's the way the general orders stand today. The orders also do not mention avoiding repeated identification attempts with the same witness and same suspect. And as you get into this area, you'll find that one of the most suggestive things that an officer can do, in other words, the worst thing they can do, is show the same photo over and over to the witness until they become familiar with that person's face and are more likely to pick it out. The general orders don't mention avoiding that procedure. And then there's an interesting little reference in the general orders, and it refers to form PD 0163. And as I was reading through that, so I've never heard of PD 0163. That must be somewhere in these general orders, and I couldn't find it. And I went online and I couldn't find it. Finally called APD, and I talked to somebody in their public administration office, and I said, can you get me a copy of that? And they said, sure, yeah, we'll send it to you. This is a really interesting form that they all know about, but they won't give to the public without a request. And it's just a single sheet, and they have to read it to the witnesses. These are the written instructions they have to give an eyewitness ID, an eyewitness in any ID procedure, and you can just send a request to that email address and you can get the latest version of that form. It says to the witness, you are being asked to view a series of photographs. This series of photos may or may not contain a picture of the person who committed the crime now being investigated. You shouldn't feel like you have to make an ID. It is just as important to exclude innocent people as it is to identify the perpetrator. You don't have to make an ID if you don't recognize an individual as the person who committed the crime. And the investigation will continue whether or not you make any ID. That's really important. Bravo, APD. That's a great thing to put in there because the person's not going to feel like they just have to pick somebody. They know that the investigation will continue. Individuals depicted in lineups may not appear exactly as they did on the date of the incident because features such as hairstyle or facial hair may be easily changed, and a person's true skin tone may be lighter or darker than it appears in the photo. Take your time, look at each photo. If you recognize a person, do you recognize him or her as being the person that you saw? Describe the act in your own words. And there's actually several lines on that form where the witness writes out that they recognize the person and they describe it in their own words. And finally, they have to describe in their own words how confident they are on the ID, super important. And don't tell other witnesses that you have or have not identified anyone. These are all really good suggestions. It's good that APD is doing this and that they have a form. If they don't read that form and if they don't have the witness sign off on it, I think that's a big deal. That's a big deal for cross. You should have the form. You should impeach the officer. You should ask them why they didn't do it. Because there's a reason this form exists. There's a reason that those general orders exist. They want to get it right. If they don't read the form or the witness's confidence is low, you'll have it, but you need to request that form in discovery. In 2020, Gary Wells comes out with a new white paper and he adds 5 additional recommendations. So we're seeing that this is progressing. The science is changing. The recommendations are changing. Law enforcement is starting to adopt these things. And in addition to the 4 preliminary recommendations, he says, conduct a pre-lineup interview of the witness. That could be the form that APD is showing them. It could be, just trying to find out as much information of the description of the perpetrator as possible. This says, it's kind of wordy, but they want the officer to have probable cause before they put someone in a lineup. Don't just put somebody in a lineup because they're there. Video record the entire procedure. Really helpful. We want APD to do that. We want all law enforcement to do that. Avoid repeated ID attempts and the same witness and same suspect with same witness and same suspect, and avoid the use of show-ups when possible, and improve how show-ups are conducted when they are necessary. Again, discouraging law enforcement from using these single person photos or single person field show-ups. They're highly suggestive, and it could sabotage law enforcement's case. And they should be impeached anytime they do this, because if there is a photo array possible, that's the method they should go with. All right. How much time do we have, Betty?
You've got about 5 minutes.
All right. Really quick on excluding eyewitness ID. These are the major cases. They're called the Stovall line of cases. I'll leave it to you to read them and see if they apply in your cases. There are 2 kinds of ID. The first one is when they're out on the street and they're trying to identify somebody. The second one is in court. And you usually hear the court say, or prosecutor asks the witness, is the person you saw that night in the courtroom today? The witness says, yes, he's right there sitting at counsel table. If you've done a good job of trying to exclude the eyewitness pretrial, you should be on your feet objecting at this stage right now, because if this comes in without objection, it devastates your case. You've just waived all of your objections by letting it come in at trial. So you need to object to the identification in court. So there are really 2 parts to exclusion. The first one in your memo, in your motion, in your brief, ought to be that the photographic display was impermissibly suggestive. And a single photograph or a single person ID, those are going to be considered per se impermissibly suggestive. But that's not the end of the analysis. You have to go to part 2 And part 2 says, if it was impermissibly suggestive, if the procedure just sort of gave it away and told the witness who to pick, or was just otherwise very suggestive, the courts need to look at whether the suggestive pretrial procedure gave rise to a very substantial likelihood of irreparable misidentification in the future. So just having a suggestive lineup procedure, it's good. You need to show that, but you also have to show that this witness has now been trained and will only identify this one person because of the procedure that was used. And it could have been a slap on the back where the officer said, you got him. Or it could be talking with a co-witness who said, yeah, I picked him too. Or it could be any number of things where the police, through their procedures and through the practices that happen after the procedures, reinforce in the witness's mind that they got it right. And they are never going to deviate or veer from that position, that the person that they chose during the initial eyewitness ID is the very same person who's on trial. You got to prove it by clear and convincing evidence, which is a big hurdle. But I think as these cases come to judges and courts, especially in Travis County, I think they'll be amenable to your arguments, especially if you can make the case that the procedure itself was suggestive. The police didn't follow their protocols. They didn't follow the statutes. They didn't follow model policy. And this witness, because of those procedures, is just locked in. They're never going to say anything else. I'm going to skip ahead. Right here starts a series of Texas cases that you can read on your own time. I'm going to distribute this PowerPoint. It'll have all this information in it. But you can get an idea of cases that have looked at and decided what areas are impermissibly suggestive. And some of them may seem obvious, some not so obvious. But, you know, as I said before, the one hallmark of a per se impermissibly suggestive ID procedure is showing a single photo and asking, is this the guy? Or a show up that's going to be impermissibly suggestive. Make sure that you preserve the photo array, or that the police preserve it, that you have it. If they don't, that's considered impermissibly suggestive. Take a look at federal cases. They deal with the same due process issue that we're dealing with in state court. And look at your facts. Try to get as much information as possible. I think these bigger factors are very important. They are important because the courts keep citing to them. I don't think that they really are helpful in terms of making the decision about whether a witness is locked in and will never change. For instance, number one, the witness's opportunity to view the criminal at the time of the crime doesn't really tell us a whole lot about whether they're locked in or whether the identification it gives rise to an irreparable identification. Witnesses' degree of attention, their accuracy of the prior description, their level of certainty, and the length of time between the crime and the confrontation. I think that's about all the time I have. I don't know if there are any questions, but thank you very much for allowing me to speak on this. There's a lot more to the topic, but I encourage everybody to look into this and see if you have an eyewitness ID case. Refer to these materials. Come ask me if I can, I'll help. But just keep paying attention to it.
Anybody want to post it in the Q&A while you've got the expert here? This would be great. I was just shocked having been to several national seminars, and I think I even heard Bill Allison talk about the sequential double blind back in the 90s, and talking to APD in 2000, they had no idea what it was.
Yeah.
They literally had no idea what it was. It's like, wait, what? The FBI has adopted this. What do you mean? And so this is huge. Those change of general orders is huge. That's a huge, definite improvement. The biggest problem I always found was the show up at the scene. Like you have a rape case or a sexual assault case where the person has fled and they use a dog and go find somebody, and bring them back. It's just they're in handcuffs, they're surrounded by the cops, the lights are
Right.
on them. There's one person.
Well, I think that it makes law enforcement's job easier to be able to just take an individual, a suspect, and ask the witness, is this the guy? Than to try to cull photographs, make them match the suspect or the description of the perpetrator, set up an appointment with the witness at a later time. It's just much more complicated to do this, but I think we get into problems when police try to do it the easy way and just do a single person show up.
Out at the scene, which, yes,
Right.
lots of robberies that occurs, they bring them right back to the place of the robbery. So that's a huge problem, in my opinion. So anybody else have any questions? Well, David, that was fantastic. If you will stop sharing your screen, I will share mine for the CLE number. Great. Let me see if I can get to mine. There it is. And David, if you want to take teaching credit, this is the number that you use to log as many hours as you had worked to put this together. For all of you
Thank you,
watching
Betty.
this live version, CAPS will report this for you. If you need it reported sooner or you're watching the recorded version, you'll need to report it to the state bar. They only allow us to have the number be good for 11 months, so you'll need to report it in the next 11 months. But that is the number. And I have to stop sharing my screen to see if anybody posts any questions. Let me see. Nope, we're doing good. Just thank you so much. That is just so interesting and just a huge part of our cases. And you see these fantastic, sad cases where someone has spent years in prison and then DNA finally exonerates them. But as we know, so many of these cases, there is no DNA, robbery cases, there is no DNA, right? And
That's right.
so it's a huge problem, because once the law enforcement forces to them that that's a person, they're just going to pick that person, every
That's right.
time they see that person, every pretrial you have, every time they come to court and see that person in court in handcuffs,
Well, robbery cases you never see DNA left behind. Sexual assault cases, you often do. And eyewitness ID comes up in those cases on stranger sexual assaults. The problem is they haven't been keeping DNA, since before the 90s. And
Right.
so on a lot of these cases, they're still being considered, for rape kit cases, and a lot of DNA exonerations haven't happened yet. So we don't know about those cases where eyewitness ID was involved.
Right. So that's why it's so important. And I really appreciate you taking the time to speak with us today. It was great. It was fascinating. I really
Thank you very much.
appreciate it.
Appreciate being here.
Thank you, everybody. Have a wonderful weekend. Take care.
Thanks. Take care.
Bye-bye.